Okay, good afternoon to everyone for this session. In the LawScope session for today, I'm Jotpreet and I'm going to be talking about the most important current legal news that have taken place from the 16th to 31st of March 2022. So let us quickly begin with the most important court judgments and orders. In this session, we will also be talking about some important bills and acts that have come in this time period. So beginning with the court judgments and orders, let us quickly begin with the very first judgment, that is Ajay Kumar Rathi versus Seema Rathi. Now, Ajay Kumar Rathi versus Seema Rathi was a case between a father and a daughter. In this case, basically, क्या होता है जी? The daughter is of that opinion where she does not want to maintain any relation or any ties with the father. वो कहते हैं कि मुझे फादर के साथ कोई रिलेशनशिप ही नहीं रखना है, but she expects that the father shall pay for all of her expenses, for all of her education, as well as for her marital expenses. तो इसमें बेसिकली जो क्वेश्चन था बिफोर द कोर्ट वाज, क्या एक अनमैरिड डॉटर, the one, this daughter not wanting to maintain any ties with the father, is the father liable to now pay any amount or any maintenance to this daughter? So basically इस क्वेश्चन को आंसर किया है जी सुप्रीम कोर्ट ने in this case. So what has the Supreme Court said? The Supreme Court has clearly stated that daughter is not entitled. She will not be entitled to any money from father if she is not entitled to any money if the father does not want, if she does not want to maintain any ties or any relation with the father. अब अगर हम मेंटेनेंस की जनरली बात करते हैं तो हमें दो चीजों को कंसिडर करना चाहिए. नंबर वन, इन रिस्पेक्ट ऑफ डॉटर्स हम माइनॉरिटी की बात करेंगे. अगर एक डॉटर माइनर है, क्या फादर को उसे मेंटेन करना पड़ेगा या नहीं? In case of a minor, the father has to ensure that he maintains the daughter in respect of all of her expenses, specifically for education and all other basic expenses. But अगर एक डॉटर मेजर है, तो अगर मैं मेजर की बात करूं, that is if she is above the age of 18 years, in that case please remember एक unmarried daughter के relation में the father can be held liable to pay maintenance, and not just that, he will also be liable to pay the basic expenses in case of a marriage. So unmarried daughter, if she is a major, then the father will be bound to maintain her. But इसमें difference क्या था? We had the daughter of 20 years of age and she said, I do not want to keep any relation or any know-how of my father at all. And she wanted that I shall be able to do whatsoever I want and be able to pursue my own path in my life. And further, she did not want any interference from her father's side. But then she wanted that the father shall be liable to pay for all of her education and marriage expenses. तो यहाँ पे Supreme Court ने clearly कहा है that a girl being a major, she is free to do as she likes. She can take up her own path, and वहाँ पे no, the father, if she does not want to keep any relation, any ties with the father, then the father is not bound to maintain her. ये आया था जी हमारी वेरी फर्स्ट जजमेंट, दैट इज अजय कुमार राठी वर्सेस सीमा राठी में. लेट्स मूव टू द नेक्स्ट जजमेंट. The next judgment was the state of Karnataka and others versus state of Meghalaya and others. Right, so this was regarding the state of Karnataka and others versus state of Meghalaya and others. अब इस केस में basically what was the basic question that was talked about? यहाँ पे the question that came up before the Supreme Court was that whether lotteries should go, the taxes that we get from lottery, should they go to the central government or should they go to the state government? तो बेसिकली हमारा शेड्यूल नंबर 7, राइट, शेड्यूल 7 लिस्ट्स जो हमारी है, यूनियन लिस्ट, स्टेट लिस्ट एंड कंकरेंट लिस्ट के अकॉर्डिंगली दिस वाज dealt with. So basically what is the stand of Supreme Court in this regard? So the Supreme Court has stated that जहां पे भी लॉटरीज की बात आएगी, here they could have come or they could be issued by any entity. Any entity का मतलब गवर्नमेंट होगा, स्टेट गवर्नमेंट हो सकता है, सेंट्रल गवर्नमेंट हो सकता है, एक प्राइवेट एक एजेंसी या इंस्ट्रूमेंटालिटी ऑफ द स्टेट और सेंटर, या फिर एक प्राइवेट प्लेयर हो सकता है. इन एनी ऑफ दीज केसेस कोई भी अगर एक लॉटरी को इनिशिएट कर रहा है, इशू कर रहा है, वी आर ओनली कंसर्न कि ये जो मैटर है ऑफ लॉटरीज ये कौन सी लिस्ट के अंदर है. सुप्रीम कोर्ट हैज स्टेटेड फर्दर दैट जो लॉटरीज हैं दे आर अंडर बेटिंग और गैम्बलिंग, बेटिंग या गैम्बलिंग के अंदर इंक्लूड होंगी, विच इज अ पार्ट ऑफ योर एंट्री नंबर 62 ऑफ लिस्ट 2. मतलब ये स्टेट लिस्ट का मैटर है, राइट, बिकॉज ये स्टेट लिस्ट का मैटर है, hence all the tax proceeds in respect of lotteries shall go directly to the state government. There can be no sharing between the union government or the state government in the matters of lotteries, because lotteries are a part of betting and gambling as given under entry 62. सिमिलरली इसी केस में आगे ये भी कहा गया है कि एंड क्लियर करा गया है कि जो लॉटरीज हैं वो यूनियन लिस्ट की एंट्री 40 के अंदर नहीं आती है. दिस इज व्हाई द टैक्स प्रोसीड्स फ्रॉम लॉटरीज विल नॉट गो टू द सेंट्रल गवर्नमेंट. नाउ मूविंग टू द नेक्स्ट वन, दैट इज स्टेट ऑफ उत्तराखंड वर्सेस डॉक्टर संजय सिंह चौहान. अब डॉक्टर स्टेट ऑफ उत्तराखंड वर्सेस डॉक्टर संजय सिंह चौहान के अंदर बेसिकली किस चीज की बात करी गई है? दिस वाज रिगार्डिंग द कॉन्सेप्ट ऑफ इक्वल पे ऑफ इक्वल वर्क इन रिस्पेक्ट ऑफ टू कैटेगरीज ऑफ डॉक्टर्स. एक है जी आयुष के डॉक्टर्स एंड दूसरी तरफ एलोपैथिक डॉक्टर्स. सो बेसिकली what has been talked about in this judgment is कि जो आयुष के डॉक्टर्स हैं, now all of the doctors involved in Ayush shall be entitled to equal pay as that of allopathic doctors. This is what has been stated. Just some time back we had another case that had also dealt with another matter that was similar in this regard, that was regarding equality in respect of superannuation age. ठीक है, सो बेसिकली ये सुपर एनुएशन एज हमारे एलोपैथिक डॉक्टर्स के लिए बढ़ा दी गई थी, बट आयुष के डॉक्टर्स के लिए नहीं बढ़ाई गई थी. सो नाउ अर्लियर इन अनदर केस ये जो सुपर एनुएशन एज था, दिस वाज इक्वल्ड टू योर other allopathic doctors. Now why are we talking about this is because please remember doctors under Ayush are entitled to equal pay as that of allopathic doctors. तो यहाँ पे दो principles की बात करना बहुत जरूरी है. Number one, that is equal pay for equal work, जो हमारा एक directive principle है. And basically इसके अंदर क्या है, that wherever any person is involved in similar natured tasks या same या similar, वहां पे that person will be entitled to equal pay for equal work. मतलब same काम के लिए आपको same wages मिलनी चाहिए, right? So any sort of discrimination would directly lead to violation of article number 14 of the constitution, which is again very very important from exam point of view. So please remember क्यों ये करा गया है, because equal pay को अगर हम नहीं गारंटी कर रहे हैं तो वो डायरेक्टली हमारा आर्टिकल 14 ऑफ द कॉन्स्टिट्यूशन की वायलेशन है. Moving to the next judgment, let's talk about MC Barwala, District Hisar, Haryana, through its Secretary President versus Jay Narayan and Company and others. तो इस केस के अंदर बेसिकली वी आर गोइंग टू टॉक अबाउट द कॉन्सेप्ट ऑफ ऑक्शंस. नाउ प्लीज रिमेंबर auctions is a very important part when we talk about your concept of contract law. Now इस केस में ये कहा गया है that merely just being the highest bidder, मतलब आपने highest bid दी in any auction does not confer a legal right to that auctioned product. क्यों? Basically ये क्यों करा गया है? This is because, please understand, there are certain rules, regulation and approvals that are to come in later on as well. अब चाहे आपकी highest bid थी, but you somehow failed to pass through all of the other rules and regulations, तो वहां पे you will not get a legal right to that bid. यही आया है इस केस के अंदर. So a bench has, now the bench in this case has held that the highest bidder in an auction does not have any legal right and equitable right to claim the auction property until and unless the same has been approved by the state government. So auction को highest bidding is not the only condition. There is a subsequent rule कि state government approve करेगी. जब तक state government approve नहीं करती है तब तक आपका कोई लीगल राइट नहीं बनेगा ऑन दैट ऑक्शन. हाउएवर द मोमेंट जो स्टेट गवर्नमेंट ने आपका अप्रूवल दे दिया, then your legal right will be acquired. Now why we talk about auctions is because यहाँ पे अगर मैं contract law की बात करती हूँ तो contract law के अंदर we talk about your concept of invitation to an offer. Please remember क्यों ये इंपॉर्टेंट हो गया है? बिकॉज यहाँ इस जजमेंट के बेसिस पे आप इन्विटेशन टू ऑफर फ्रॉम कॉन्ट्रैक्ट लॉ विल बिकम अ वेरी रेलेवेंट टॉपिक फॉर द एग्जाम्स दिस ईयर. Why? Because auctions are nothing but an invitation to an offer, जहां पे जो bidder है वो actual में offer देगा and the acceptance will be complete the moment the hammer falls. ठीक है, तो प्लीज इन चीजों को ध्यान रखते हुए प्लीज रिमेंबर देयर आर सर्टेन एडिशनल situations and claims that have to be approved for that auction to be completed. Moving to the next judgment for the day, that is State of Karnataka versus Umesh. Now in this judgment basically what has been talked about is the principles regarding your disciplinary inquiries. Please yaad rakho that a case and a disciplinary inquiry are different things. Disciplinary inquiries are similar to a departmental inquiry or a departmental investigation, जहाँ पे डिपार्टमेंट की जो अथॉरिटीज हैं वो किसी भी ग्राउंड पे, what are the grounds? Naturally वो होते हैं maybe there is some misconduct, there is some illegality, and ऐसे grounds पे डिपार्टमेंट में एक investigation can be conducted. Now for this basically please remember Supreme Court has clearly stated that a departmental inquiry is separate and very different from a criminal trial. So what are they actually talking about is the level of proof required. Now level of proofs के अंदर दो चीजें आती हैं. One is a beyond reasonable doubt. The other one is beyond your जहां पे आपका preponderance of probabilities आता है. ये this is nothing but the level of proof required in a certain case. Now please remember criminal cases require highest level of proof because यहाँ penalties and punishments are stringent. But in civil cases और इस केस में departmental inquiries में you only need to establish the facts up to the level of preponderance of probabilities. तो यहाँ पे अगर मैं बात करूं तो beyond reasonable doubt का मतलब ये होगा. So we are differentiating between two concepts, that is beyond reasonable doubt on one end and the other is preponderance of probabilities. ठीक है, preponderance of probabilities. It's nothing but a level of proof that you're talking about. Evidence law का perspective है. Now beyond reasonable doubt का मतलब ये होता है that any person now Once all of these evidences come up before the court, it is absolutely clear that this person has actually done that wrong. तो वहां पे there is not even that one single element of a doubt. ये होता है जी beyond any reasonable doubt. Whereas in preponderance of probabilities, अगर मैं इसको proof की बात करूं, तो even if you go halfway, more than halfway, here आपका proof वहां पे आ जाएगा. That is how these two levels of your evidences are going to vary. In civil cases, preponderance of probabilities is the required level of proof. However, in criminal cases, it must be proved beyond any reasonable doubt. कि मतलब इतना सा भी doubt नहीं रहना चाहिए in the mind of any person. तो यहाँ पे इस केस में क्या कहा है कि अगर हम डिसिप्लिनरी इंक्वायरी की बात करें, ये एक क्रिमिनल ट्रायल नहीं है. So यहाँ पे even if the proof is at this level, which is lower than beyond reasonable doubt, it is absolutely valid. In this case, further, what has been said? Now, it has been stated that the acquittal of the accused in a criminal case does not debar the employer from proceeding in exercise over disciplinary jurisdiction. मतलब चाहे उस person को criminal case में acquittal मिल गया, that is, there was no actual proof, yet जो employer है, he has a right that he can make a or he can proceed with a disciplinary inquiry in his own department. Now, इसी के अंदर beyond reasonable doubt नहीं चाहिए and preponderance of probabilities is sufficient. So what has the court further stated? Now, unlike a criminal prosecution, where the charge has to be established beyond reasonable doubt, in a disciplinary proceeding, a charge of misconduct has to be established on preponderance of probabilities. Now, some time back we had a case जहां contributory negligence के case में criminal acquittal हो गया था, but वहां पे disciplinary inquiry का जो action था absolutely valid था, because वहां पे the actual negligence was still established. तो यहाँ पे कोर्ट ने क्या कहा है? The court has held that the exercise of judicial review powers in disciplinary proceedings must restrict to determine only the following. Of the following, the court has clearly given directions. What are the things that the court has to keep in mind while they're determining a case under a disciplinary proceeding? Number one, the rules of natural justice have been complied with. So we have 3 rules of natural justice. पहला है जी हमारा no bias rule. Second, the rule of audi alteram partem, that is giving every party the right to be heard. And last is कि एक reasoned decision होना चाहिए. This is the first thing that has come from here. The second is the finding of the misconduct was based on some evidence. कि ये जरूरी है कि actually में कोई evidence था. Without evidence, we cannot hold a person guilty. Third, the statutory rules governing the conduct of the disciplinary inquiry have been observed. मतलब आपने जो ये inquiry conduct की है, it has been conducted in a lawful manner, keeping the law rules in mind. Next, whether the findings of the disciplinary authority suffer from any perversity. Right? So there should not be any sort of lacking or any bias in that manner. And lastly, the penalty is disproportionate to the proven misconduct. Okay? So please understand that these were the 5 guidelines that have been put forward on your matters of disciplinary cases. Let's move to the next judgment. Okay, finishing off all of the judgments, now let us talk about some important bills and acts that have come in this time period. Now, in respect of bills and acts, first bill or act is the talks and your commission in respect of amendments to IPC and CRPC. IPC and CRPC के अंदर, please remember the 146th report submitted by the Parliamentary Standing Committee has now stated कि instead of making small little amendments to IPC and CRPC, जो हमारे criminal laws हैं major, Indian Penal Code and the Criminal Procedure Code. Now, instead of making small little amendments in these laws, we should make a comprehensive review of the full law and now come up with a whole new comprehensive law. ये आया जी आपकी 146 रिपोर्ट as submitted by the Parliamentary Standing Committee. इससे पहले in its 111th and 128th report, the Parliamentary Standing Committee had stated the need to rationalize and reform the country's criminal law by introducing comprehensive legislation in the Parliament instead of bringing irregular amendments. वही चीज है, उसी को अब emphasize करा है 146 report में. Next, the amendments are being done to make comprehensive changes in India's criminal laws so as to provide speedy and affordable justice to the people of the nation. तो क्या objective है? Speedy and affordable justice. तो यहाँ free legal aid के ऊपर emphasis ज़्यादा करा जाएगा, as well as keeping in mind the COVID situation. We've also seen a lot of tele-law methods come in, your virtual courts and all of these things. So unko kahin na kahin they will try to bring this into the new codes, right? It will also create a legal structure for its people-centric approach. Lastly, what is also very important is that under the chairpersonship of Ranbir Singh, who is the VC of National Law University Delhi, a committee has been constituted to suggest law और criminal law reforms. बहुत important है किसकी chairpersonship के अंडर या under whose chairpersonship नई committee बैठी है for the changes to the criminal law. This is under Mr. Rajbir Singh, who is the Vice Chancellor of NLU Delhi. बहुत important है. This is very, very important from exam point of view. इस type के questions हर year definitely आते हैं. So try to keep that in mind. Moving to the next one, let's talk about your Delhi Municipal Corporation Amendment Bill 2022. Basically, what was the purpose of this bill? Let us quickly go through. We've had a lot of talks about this bill around this past 1 week and a half. तो इसमें basically क्या हुआ है? Now, एक चीज याद रखो, the municipal corporations के perspective में ये bill आया है. पहले क्या था? Delhi Municipal Corporation Act of 1957. This was passed by the Parliament. ठीक है? तो इस बिल के अंदर क्या हुआ था? The Act had amended the 2011 Delhi Legislative Assembly Act and इसके अंदर उन्होंने municipal corporations को 3 में divide किया था. So now from 1 it was now trifurcated. ठीक है? Trifurcated का मतलब उन्हें 3 में divide करा गया था into North, South Delhi and East Delhi municipal corporations. तो 3 में इन्हें divide करा था. अब ये जो बिल आया है इन्हीं तीनों को वापस एक बनाने के लिए आया है. Now let's talk about what are the points that have come in this bill, because इनके ऊपर कोई भी एक छोटा question आ सकता है. Now, Act as amended in 2011 empowers the Delhi government to decide various matters under the Act, such as the total number of seats of councillors as well as the delimitation of wards. मतलब delimitation में कौन से ward में कितने लोग बैठेंगे या नहीं. That is the concept of delimitation. But ये जो नया bill है, it now empowers the central government to decide these matters. ये power Delhi government से ले दी गई है and इसको अब central government के पास दे दिया है. Next point, the act provides that the number of seats in these 3 corporations shall not be more than 272. But जो नया bill है, they have reduced this number to 250 and they have put a bar on this. मतलब 272 से लेके अब 250 हो गया है. अगला जो पुराना एक्ट था, that provided for a director of local bodies to assist the Delhi government and to discharge certain functions. तो यहाँ पे एक director of local bodies था, that was to sit with the government and to advise them in certain perspectives. अब इस बिल ने डायरेक्टर ऑफ लोकल बॉडीज की जो प्रोविजन थी उसको रिमूव कर दिया है. नेक्स्ट, the bill provides that the central government may appoint a special officer to exercise the powers of the corporation until the first meeting of the corporation is held आफ्टर द कमेंसमेंट ऑफ द बिल। तो मतलब जितने टाइम तक ये बिल शुरू नहीं होगा तब तक सेंट्रल गवर्नमेंट एक स्पेशल ऑफिसर को अपॉइंट कर सकती है। सो इफ यू वर टू लुक एट दिस एंड अंडरस्टैंड, द सेंट्रल गवर्नमेंट्स पावर्स हैव बीन वाइडेंड, whereas the Delhi Municipal Corporation में जो दिल्ली गवर्नमेंट का ज्यादा कंट्रोल था, it has now been slightly restricted through this bill. Now, this bill has been passed in the Lok Sabha and recently in the Rajya Sabha as well. Let's move to the next bill that has come in. This bill is the constitutional. Yes, so this is the Constitution Scheduled Tribes Order Amendment Bill 2022. This one is basically dealing with a matter जहां पे एक नई community को add किया गया है within the scheduled tribes of Tripura. ठीक है, so the Lok Sabha passed a bill to introduce which tribe? The tribe is known as the Darlong tribe. The Darlong community as a sub-tribe of the Kuki tribe on the list of scheduled tribes of Tripura. तो इसी के लिए अगर हम बात करें, let's just quickly finish, then I'll talk a little more. That is moving the Constitutional Scheduled Orders Amendment Bill 22 in the Lok Sabha. The Tribal Affairs Minister said that the Union government was working towards betterment of living conditions of tribal communities. Please remember your वेरियस मैटर्स इन रिस्पेक्ट ऑफ, अगर किसी भी ट्राइब को हमने इंक्लूड करना है, किसी भी कम्युनिटी को शेड्यूल्ड ट्राइब्स के अंदर इंक्लूड करना है, इसके लिए एक प्रॉपर स्पेशल अमेंडमेंट आएगी इन द कॉन्स्टिट्यूशन, राइट? सो फॉर दिस, यस, try to read the important provisions in respect of scheduled tribes. What are the various ways by which the constitution has now, promoted the interest of the scheduled tribes? अगर हम article 19 की बात करते हैं, 19 के अंदर अगर हम बात करें the right of residence and the right to reside in and to move about and to settle in any part of the country, they are restricted on the matters of areas that are protected under scheduled tribes. So please remember, scheduled tribes के लिए जो भी protective measures हैं, उनको एक बारी आपको देखना जरूरी है for the exam point of view. Also do deal with the various schedules that are talking about the rights of the scheduled tribes. Moving ahead. फिर आता है जी हमारा क्रिमिनल प्रोसीजर आइडेंटिफिकेशन बिल ऑफ 2022. अब ये क्रिमिनल प्रोसीजर आइडेंटिफिकेशन बिल में क्या हुआ है जी? ना बेसिकली इसको वाइडली क्रिटिसाइज भी करा गया है बिल को. व्हाट इज द रीजन, व्हाट इज द पर्पस? लेट अस गो थ्रू द प्रोविजंस फर्स्ट. इस बिल के थ्रू जो हमारी पुलिस एंड प्रिजन अथॉरिटीज हैं, तो कौन है? Police as well as prison authorities. So two entities now get the right to collect, to store and to analyze physical and biological samples. You can collect and physical as well as biological samples including retina and iris scans. So the eye scans introduced now in the Lok Sabha. मतलब ये बिल को हमने अभी इंट्रोड्यूस करा है लोक सभा में. ठीक है जी. तो बेसिकली किसके पास अथॉरिटी आएगी? पुलिस एंड प्रिजन अथॉरिटीज. Now the bill also seeks to apply these provisions to persons held under any preventive detention law. ठीक है, मतलब अगर आपने किसी को प्रिवेंटिव डिटेंशन के अंदर भी डिटेन किया है, that is given under article number 22 of the constitution. अगर आपने article 22 के preventive detention में आपने किसी को detain किया है, उनका भी आप सारे physical and biological samples maintain कर सकते हो, and this data can be preserved for at least 75 years. This is the basic purpose of this bill. Now, अगर हम बात करें, we've also had in 2018 your right to privacy judgment, जो हमारी KS Puttuswamy judgment आई थी, in which right to privacy was declared as a fundamental right under Article 21. This thing will directly target and go and violate that provision of our constitution. तो इसीलिए यहाँ पे बहुत ज्यादा कंट्रोवर्सी है एट दिस पॉइंट ऑफ टाइम, बिकॉज राइट टू प्रिवेसी के ऊपर कहीं ना कहीं इस चीज ने टारगेट किया है. What is the basic bill going to repeal? This bill will repeal the Identification of Prisoners Act 1920, जिसका scope limited था to recording only fingerprints and footprint impressions of limited category of convicts and non-convicted persons. और also इसके beyond बस photographs रखने का authority था and nothing beyond that. So please remember यहाँ पे बहुत एक्सटेंसिव कंट्रोल दिया जा रहा है टू पुलिस एंड प्रिजन, एंड यहाँ पे आपका आर्टिकल नंबर 20 naturally is going to be violated. आर्टिकल नंबर 22 को हम मिसयूज कर रहे हैं. So please remember आर्टिकल 20 अगर मैं बात करूं what all constitutional provisions are to be kept in mind. आर्टिकल 21, Article number 22, as well as Article 20, Clause 3, that is no self-incrimination. That is, no one can be compelled to be a witness against himself. That will also come into a question over here. Now, bill will imply use of force in collection of biological information. This could lead to forced narcolysis, brain hacking, and this is naturally a major drawback. ये बहुत major criticism है कि Article 20 Clause 3 को ये violate करेगा. Right to privacy under case Puttaswamy case को भी violate करेगा. So do ensure that you follow this bill very closely and go through the provisions and criticisms very properly. जब आप इनको अच्छी तरह से पढ़ेंगे, you will also relate these with article number 21, 20 clause 3, that is right against self-incrimination, and lastly preventive detention का misuse, KS Puttaswamy judgment, and जो भी आपकी provisions हैं in respect of rights of prisoners, do ensure that you go through these. Now, let's move to the last bill that was there in this. That is the bill of anti-lynching bills. Anti-lynching, please remember, lynching was the process जहाँ पे the crowd, they come together and on any ground, okay, any ground where they have a aggression on any basis. So एक mob इकट्ठा होके एक person को मारता पीटता है, due to which that person may die. The act of attacking one person, a mob attacking a person, or it could even be a set of persons, वहां पे इस concept को हम lynching बोलते हैं. We have seen many cases of lynching come across the country, जहां पे हमने specifically अगर राजस्थान राजस्थान की बात करें तो वहां पे बहुत सारे lynching के cases आए थे. Now over here इसी चीज को ध्यान रखते हुए those states, that is Rajasthan and Manipur, they had created a state law in respect of anti-lynching. Please remember, lynching became such a stringent offense that people would get together, they'd get aggressive and they'd attack one person and that person dies. इसके लिए कोई भी clear cut provision नहीं थी in the law that how do we prevent it or what is the clear punishment that is to be applied. We were directly, अभी तक हम इसको directly 299 and 300 of IPC के अंदर लेके जा रहे थे, that is culpable homicide not amounting to murder or amounting to murder under section 300. इसके सिवा अभी तक हम इसको कहीं और proper law के तौर पे deal नहीं कर रहे थे. Only two states, Rajasthan and Manipur, dealt with these two laws. Now, what has happened is there has been a need felt that हमें इसको एक central law के तौर पे लेके आना चाहिए. इसीलिए अब एंटी लिंचिंग बिल्स को इंट्रोड्यूस करने से पहले हम सबसे पहले राजस्थान एंड मणिपुर के जो लॉज हैं, स्टेट लॉज है, उनको रिव्यू करेंगे. Once we review these, then we are going to bring in a proper law on this basis. This is what was basically talked about and is very important from exam point of view, because lynching के ऊपर एक पूरा paragraph बहुत अच्छे से बन सकता है in the CLAT paper. Right, so let's go through the points that we have here and then that is where we'll wind up. So firstly, the Ministry of Home Affairs has informed the Lok Sabha that clarifications have been sought from the governments of Rajasthan and Manipur regarding their anti-lynching bills that were passed by the two assemblies in 2018 and 19. Now here the Minister of the State has stated in a written reply that lynching is not defined as a crime under IPC. IPC के अंदर कहीं पे भी lynching के बारे में कुछ भी specific नहीं लिखा हुआ है. In the annual report of crimes in India, NCRB जो publish करती है, that is National Crime Records Bureau publishes this. It has stated, ये report बनती है सारे states and union territories से under the various crime heads that are defined under IPC and special local laws. तो इसी की वजह से अभी तक इसके ऊपर एक proper report क्या analysis नहीं आ पाया है. अब 2017 में NCRB collected some data on mob lynching, hate crimes, etc. But it was observed that the data was unreliable because इसके ऊपर एक clear defined law ही नहीं है. So now further it was stated that NCRB does not maintain any data on hate speech as well as on mob lynching. Lastly, यहाँ पे कौन से दो laws है जिनको देखा जाएगा? Basically, the first is the Rajasthan Protection from Lynching Bill 2019 and the Manipur Protection from Mob Violence Bill 2018. इन दोनों को अभी आपने ये जो दो नाम है इनको याद रखना है, बस इसके ऊपर पेपर से डायरेक्ट क्वेश्चन आ सकता है. Right, so do study something about the anti-lynching bills that are there. Now, with this, we wind up today's session. I hope you found this session informative. And wherever you have any doubts, please get in touch with us. And for more such videos and sessions, please log on to our channel and subscribe our channel, HitBullsEye on YouTube. Thank you and take care.